Hello, and welcome to this edition of You and the Law. On You and the Law, we add law to the news. My name is Ekeminidim. I'm a legal practitioner, and I'm always glad to know that you are keeping me company on this channel. In this episode of You and the Law, I am discussing the legal issues surrounding the killing of the television chief executive officer, Mr. Osifo Ataga, in Lagos State, Nigeria. The news broke recently that Mr. Ataga was killed in an apartment in Lagos State, Nigeria. And after that, we've seen the police parading a young lady, a 21-year-old university undergraduate, and she has made statements to the press. And what follows thereafter is the procedure that the law requires to be followed in situations such as this. In this episode of the program, there are various legal issues that I have read on social media, I've read on print media, people asking several questions. And I have picked those questions, a few of those questions, to address them on this show. The first question I have read is the accused person entitled to be defended by a lawyer? And people are asking that question in view of the fact that what has happened is the killing of a human person. And so people are asking, is she going to be defended by a lawyer? And here is the answer. The answer is yes. As a matter of fact, if there is no lawyer to defend her, the judge cannot proceed with the trial when this matter eventually goes to court. She has to be defended by a lawyer of her choice, and if she cannot afford the services of a lawyer, the law says that the judge should appoint a lawyer to defend her pro bono. Now, where the punishment for an offense is death sentence, okay? Under the Nigerian legal system, if you kill, if you are taken to the court and found guilty, the punishment is death sentence. That is, you have to be, killed by hanging or by firing squad. So, once the punishment is death sentence, no accused person is allowed to be tried in court of law without having the services of a lawyer. So even when the accused person does not have the financial capability to hire a lawyer, the law says that the judge should get a lawyer to defend that person free of charge. So that answers the question whether Chidinma is going to be defended by a lawyer. Yes, she must be defended by a lawyer. Now let's look at the second question. The second question is, why should a person who has confessed to the offense of murder be defended by a lawyer? I have answered that question in the first one. Now, let me say one or two things about this. The lawyer, by his calling, is under an obligation to defend every person who seeks his legal services. And so you don't blame the lawyer for that. Now, the lawyer is likened, when we were in law school, the lawyer was likened to a taxi driver. We used the cap rank rule. That's the rule there. And that rule means the taxi driver is on the road. He is driving and someone flags him down. He is expected to stop and carry that passenger. And so the lawyer is not expected to discriminate the clients. And so he has, by his calling, he has a right to defend any person of his choice, irrespective of the severity of the offense that the person is standing trial for. The lawyer is also likened to a medical doctor. The medical doctor is called to treat all patients. And so when the patient is taken to the hospital, whether he was shot by the police, whether he was macheted by someone, or whether whatever happened to him is not the first concern of the medical doctor. The first concern of the medical doctor is to render medical services to someone who is in dire need of medical services at the time. So, the lawyer does nothing wrong in defending an accused person, irrespective of the severity of the offense. The profession, the ethics of the profession of the lawyer allows the lawyer to so defend. But let me say that every lawyer has the right to refuse any brief on personal reasons or for religious reason or for whatever reason. Any justifiable reason can allow the lawyer to say, okay, yes, I am free by my profession to defend anybody, but for this one, I do not want to defend because of this reason or because of that reason. There is another question, and that's the third question here. And the third question is the accused person in this matter entitled to bail? Should she be allowed to go home? And the answer is simple. The answer is that she is not entitled to bail as of right. So, she remains in prison custody throughout the trial, except there is an exceptional circumstance to justify the grant of bail to her. This is the law, and this is the practice in every capital offense. Capital offenses are armed robbery, murder, kidnapping, any offense whose punishment is death sentence upon conviction. If you are standing trial for such offenses, you are not entitled to bail as of right. So you move from the court to the prison custody and you remain there throughout the trial. And the reason is simple. It is to stop the possibility of that person running away from trial. Because when you know the consequence of what you're standing trial for, you know that you're going to be sentenced to death if you're found guilty. There is that high likelihood that if you are granted bail, you're going to escape and run away from justice. So, the young girl in this case, in the Osifo Ataga's case, if she is presented to the court for the charge of murder, she's obviously not going to be entitled to bail as of right. However, the court can still grant her bail, but on very exceptional circumstances like poor health or so, considered by the court to be so exceptional that she should be offered, bail to come home from court for the trial. There are other questions, and the number 4 question is, what are the likely offenses that she could be prosecuted for? Now, when you listen to her story, and when you also read, the stories told so far in this matter, someone walked into an apartment with another, and then he never returned. He never got out of the apartment alive. He died while there in the apartment with this person. The likely offense is murder. That's the number 1 most likely offense upon which this girl can be, standing trial for. And the second likely offense is manslaughter. Now, the difference between murder and manslaughter is one has intention to kill. The other one, there is no intention to kill. For murder, there is the intention to kill. Or there is the intention, there is knowledge that what you do to the person is most likely going to result in the death of that person. And then you go in for murder. For manslaughter, there is no intention to kill whatsoever. Someone died as a result of something, what you did to him accidentally. A typical case of murder and manslaughter is when someone is running into a moving vehicle and then the driver crushes the person dies. Most times it is caused accidentally and not intentionally. So the case of Osifo Ataga and Chidinma can either be a case of murder or a case of manslaughter. It all depends on the strength of evidence that will be presented against her by the police. If a strong case of murder is presented against her by the police, then she goes in for murder. If it is not strong enough, depending also from the evidence that she gives to the police, it could be a case of manslaughter. But here there is another question. Can the police prosecute her in this matter? The answer is no. The police cannot prosecute her. It is most unlikely for the police to prosecute her. Why? Because this is a direct offense against the state, manslaughter, murder. And so, cases of this nature are usually prosecuted by the Attorney General of the states. In this case, the Attorney General of Lagos State. But the police will have a very significant role to play in the prosecution of the matter. After all, the IPO, that is the investigating police officer, in this case, is a policeman. And so he has a role to play by going to the court to support the case of the prosecution, the case of the Attorney General of Lagos State. So generally, policemen don't prosecute this kind of murder cases like this. They hand it over to the office of the Attorney General to prefer the charge against the accused person. There is another question. Now, what will the prosecution be needed to establish in the allegation of murder, assuming the allegation of murder is, the charge of murder is preferred against her? 3 ingredients. 1, that someone died. That one is always very easy to prove. 2, that he was killed by the accused person. In this case, he was killed by Chidinma. 3, that the accused person knew or ought to have known that death was the probable or likely consequence of his or her action. The prosecution has the burden to prove these 3 ingredients. If 2 is proved without proving the other, the person will be discharged and acquitted. You can't sustain a charge of murder if you cannot prove these 3 ingredients. And know very well that the requirement of the law is that the prosecution must prove this beyond reasonable doubt. Any doubt as to who must have killed this person will be resolved in favor of the accused person. So, to get conviction, the proper thing must be done. Proper evidence must be laid before the court. If not, an accused person, irrespective of the allegation, will have to go home. Now, there is the 7th question. What she needs to prove to succeed in a charge of manslaughter? That is, what does Chidinma need to prove to succeed in a charge of manslaughter? And the answer is simple. She needs to prove that she did not intend to kill or that death occurred accidentally. If she's able to prove that, then she can get a lighter punishment, which is punishment for manslaughter and not punishment for murder. Now, there is also another question. Can her confession at the press interview be used against her at the trial? The answer is yes. As a matter of fact, the prosecution can download the video clips of the confession and play them in court during trial, because the judge has to see it being played. The judge is said not to be, is assumed not to have heard about the things that are going on in the press. And so it has to be played before the court for the court to see, and then she has to be cross-examined on the content of, the video. If that is done, the judge can rightly place reliance on the said video in the judgment of the court. Now, what are the other defenses available to her? She can plead provocation. She can plead self-defense, all depending on the theory of defense as propounded by her and as propounded by her lawyer. Now, there is another question. What is the likely punishment if she is found guilty? Assuming that she is found guilty for murder, the punishment under the Criminal Code of Lagos State is death by hanging. That's a punishment. If she's found guilty for manslaughter, the punishment under the same Criminal Code of Lagos State, in particular section 227, is life imprisonment. So, whichever way it goes, it's still a very serious thing for her to contend with. Now, there is another question. Can the judge give a lesser punishment? Does the judge have the discretion to give a lesser punishment irrespective of what has been found against her? The answer is no. Where the law has provided for the type of punishment that should be visited on an accused person, the judge has no discretion than to give the sentence or punishment as provided by the law. Where the law says that the punishment for murder is death by hanging, the judge has no discretion than to make that clear pronouncement and say that you are hereby sentenced to death by hanging until you die, or to death by the firing squad. Now, there is yet another question. Is there any room for appeal in the event of a conviction? The answer is yes. Assuming Chidinma is convicted for either murder or for manslaughter, she has a right of appeal. She can appeal to the Court of Appeal and further appeal to the Supreme Court. And what I see in this case is that whichever way the matter is going to end, any of the parties will certainly go on appeal. That has been almost the practice everywhere. If she's convicted, she will have to go to court, to the higher court for possible review of that sentence. If she's discharged, I see the Lagos State government, going to the Court of Appeal and even proceeding to the Supreme Court to test it up to that point. The last question is, we recently heard that the police arrested her father. And people have asked, were the police right in arresting, the father to the accused person? The police have advanced reasons why they, arrested her. They are saying that the father obstructed the police from arresting her. We don't know. But if that is the truth, then the police as an institution was justified in arresting her. Why? Because the law says that anyone who obstructs the police from carrying on their lawful duty is guilty under the law and can be rightly charged, to court for doing that. But assuming that the police went to look for Chidinma and they did not see her, and then they picked up the father, that will be an offense against the police. You do not arrest a man in lieu of the man's child or in lieu of the man's neighbor. You go for the person you are looking for. You don't arrest the father, in lieu of the daughter. There are so many other, issues arising from what has just happened in Lagos State. But time won't permit us to say more. Perhaps we'll say it in other editions of the show. That's the size of this show. Thank you for watching. And do remember to subscribe to this channel for regular notifications. I do hope you have learned one or two things from this very episode of the show. And I do also hope that justice will be, attained, in this matter. Remember, it was Justice Chidinma who said that justice is for the accused person, justice is for the victim of the offense, and justice is for the society. Society is very interested in what happens in this matter. Thank you for watching, and do remember to subscribe to the show.